Okay, so bail, chapter 3. I don't have any fancy slides to show you. You'll be disappointed to hear. So we're just going to have to crack on with that. So the main governing provision is the 2003 bail law. Although, just as a reminder, for anybody that's watching this in future revision time, obviously we need also to bear in mind slight variations as far as juvenile defendants are concerned. Right. So. So the 2003 law established a right to bail only where the defendant is brought before a court in connection with those proceedings. So the 2003 law, as far as that's concerned, doesn't apply to decisions on bail by the police. So we need to differentiate between police bail and court bail. So for detention and bail following arrest, you see then nobody who's been arrested for an offence is to be detained by the police unless they're acting in accordance with the 2003 PACE law. Section 37 is the important provisions in this connection. So whenever a custody officer determines there are no grounds to justify continued detention of the detained person, that person's immediate release shall be ordered, unless, as it says at footnote 236, they were already unlawfully at large when arrested. So on the run from serving some custodial sentence would be an obvious example for that. So that release there, no grounds to justify continued detention, should be a simple release, not a release on bail, unless the custody officer's view is that further investigation is needed or that the individual may be prosecuted regarding the matter in connection with which he was being detained. So there you are. Designated premises. Every place in the bailiwick is to have designated premises, and at each of those there is to be a custody officer. So in Guernsey and Alderney, that will be someone with at least the rank of police sergeant, and the custody officer should be somebody who is not directly connected with the investigation against the individual. Otherwise, there'll be a fairly obvious conflict of interest argument arising there. For SARC, the functions of a custody officer are not carried out by a police sergeant. They're carried out by either the constable, the assistant constable, or the vantenier, or by somebody else that's been appointed by either of the chief officers to act as a custody officer. And again, this time, in terms of not having the same person involved, obviously there's a manpower issue there as far as SARC is concerned. So as you can see, the functionality, investigator and custody officer are to be kept apart so far as is practicable. Yes. Mm-hmm.
What happens in Perm? If somebody commits an offence in Perm, say on I don't know, Saturday evening or so, obviously there's unlikely police there, then how do who's got the right to detain the person who says, we've got this little mini prison in Perm, but what happens, is that just going to still show or is there anything happening? No, what happens? So you call the police, they go across on what boat? I mean, well, I think they probably go on one of the lifeboat or whatever it is. I mean, I'll find out. I don't exactly know how the person will be prevented from leaving the island until the police will come, but I suspect that there must be a special constable on hand. Yeah, I think that must be right. There will be a special constable who will be able to arrest and detain the
about citizens' arrest?
No, special constable police.
Yeah, but is there not a citizens' arrest power?
Well, maybe. You get like smashing up things in the moment. You don't want to go yourself in the firing. I suspect the special constable will be then properly able to arrest and train and detain. Yes. But I will.
Someone from the cafe. Someone from the cafe.
Someone from the mermaid. Yeah, but I mean, the person who's got one place in London. I mean, there are only really three police stations. For Herman, the tenant, the people who are the mermaid, and the people who are the white person, there's not much else.
Because there's nobody else.
It's lovely.
Yeah, sounds wonderful.
It's really worth doing. Brilliant.
Yeah. I have a funny feeling I may have been there years ago. Yeah, I don't know. I don't know.
I'll find out for you.
Right, okay. Detention before charge then. So 3.4. As soon as someone's brought in under arrest, for the custody officer, as soon as it's practicable to do so, the custody officer to decide whether or not he has sufficient evidence to charge the individual with the offence for which he's been arrested. Sufficient evidence to charge means that there should usually be a charge, but it says it's also permissible for the custody officer to release without charge. Where he is released without charge, that's probably because the decision has not yet been taken, probably by the law officers, as to what the charge or whether there should be a charge. So that needs to be explained. As it says, not unusual for a detainee to be under the influence, and it's possible to continue his detention, therefore, until he can be dealt with in a way that he would be able to follow and understand. If the evidence is insufficient, which it quite often will be, I guess, when somebody first turns up on arrest, then the custody officer must either release the detainee with or without bail, or continue their detention if considers there are reasonable grounds to believe it's necessary to continue to detain the individual without charge in order to, and that's exactly the same test that you would be familiar with from PACE in England and Wales in terms of detention without charge. Obviously, there should be a written record kept of that with reasons, and as it says, the detained person should be there when that record is made. Oral explanation needed to be given in certain circumstances. If the detainee is released on bail without charge, no conditions are to be attached there. Transfer, we did look at that briefly earlier on today, but 3.9, appropriate judicial officer may authorise transfer of someone who's not been charged with an offence yet and is in police detention, either in orderly or SARC, to be shipped across to undergo police detention in Guernsey. So once our hero has been charged with an offence, again, should be released either on bail or just released, unless the custody officer considers that his continued detention is justified. And if he is an adult, which for these purposes is someone who is or appears to be aged 17 or older, that's getting back to that point about Part 5 defendants that we looked at earlier on today, then his continued detention may be based on any of 7 grounds, and you can see those down there. I don't think there's anything earth-shattering in terms of novelty value in there. They're all fairly self-evident. And we've also got a specific provision there, 3.11, whether the detained person is a juvenile, could be detained on any of those grounds, or additionally, if there are reasonable grounds to believe that it's in his own interest to continue to be detained. All right, written record, we've already thought about that. Reviews, where detention is continued by the custody officer, there must be periodic reviews. The reviewing officer must hold at least the rank of inspector. Again, that's, I think, identical to the PACE regime in England and Wales. After charge, reviews carried out by the custody officer. First review must be done within 6 hours, subsequently not more than 9 hours, and generally nobody detained for more than 24 hours without being charged. And I think that's all pretty much identical to the PACE system in England and Wales. All right, police granting bail. So as it says, release won't be on bail unless it clears to the custody officer that further investigation is needed or proceedings may be taken against him regarding a matter with which he was being detained. So otherwise it'd just be a simple release, go away. But if the police do release somebody on bail pre-charge, then no conditions can be attached to that. Once they have been charged with an offence, though, they may be released on conditional bail by the police, and those conditions have to be seen as necessary to prevent absconding, offending, interfering with witnesses, or otherwise obstructing the course of justice, which are, of course, the standard big 3 as far as withholding bail is concerned. But this is conditions being attached, so same sort of philosophy, really. Again, there has to be a record of the reasons and a copy of that has to be given to the individual, presumably should they wish to apply for variation or indeed cessation of those conditions. Variations picked up at 3.17 and onwards there. Application to, as it says, the appropriate court to either strike out the conditions or vary the conditions. The court may then impose conditions which are more onerous than those that were originally imposed. All right, release on police bail to attend at a police station or a designated place of detention. The custody officer may basically write it off, say that the attendance is no longer required. So that would perhaps be where investigations continued or inquiries continued, came to nothing, or whatever it was they were looking for, they didn't find, and they just terminated the investigation, basically. So it says, apart from that, if somebody is released on bail with a requirement to attend, come back to a police station, and they fail to attend, then they are subject to arrest without warrant. Remands to police custody or customs detention. So a defendant who appears in the magistrate's court or the royal court sitting as an ordinary court, so it says they're exercising, when the ordinary court is exercising its summary jurisdiction, can commit a person to be detained at a police station for up to 3 clear days to allow the police to inquire into other offences. But again, there should be periodic reviews, and as soon as detention is no longer necessary, the individual in that situation must be produced back before the court, presumably with a view to securing their release. Similar point as far as customs detention is concerned. I haven't worked out how long 192 hours is, but it's longer than 3 days. So, yeah. Anyway, that's that. Production in court. So if the police charge, or somebody is charged whilst at the police station, and then the custody officer detains them, refuses to release them on bail, then as you can see, 3.21, the individual must be produced before the appropriate court as soon as practicable, which would normally mean, and not, well, it says, and not later than the first sitting of that court after being charged. Appropriate court is just a geographical determination. So detained in, interestingly, Guernsey, Herne, or even Jetty. I don't know, who's the arresting officer in Jetty then? Someone's just swum over there, is it? Oh. Well, commit offences on private property. Probably parachutes, a bit of parasending or something from a speedboat. Yeah. Anyway, so yes, if anyone's detained in Alderney, the appropriate court is the Court of Alderney, and anybody in Sark is the Court of the Seneschal. So fairly obvious there, really. So it says again, a detainee who is released on bail after being charged, that would be bail without conditions, it being police bail, unless the custody officer considers, well, we've already looked at that, so I'm not going to repeat that again. Yeah, sorry.
In practical terms, if somebody is arrested and charged in relation to a very serious offence on a Friday night, it may well be the case that the court will be convened exceptionally on the Saturday to make sure that person is then sent to prison. So that's what happens in practice.
Right, court bail. Let's see, as it says there, the 2003 bail law was brought in to make sure that the Guernsey bail system was ECHR compliant. That's the basic idea. And you've got just an introductory point there from section 1 of the 2003 law, and then the text from Article 5, which is what the bail law is meant to be compliant with. So, as it says, if someone is who's been charged with a criminal offence is brought before the court in connection with that offence, or applies to the court either to be released on bail or to have any existing conditions varied, he has a right to bail, but that's subject to the exceptions set out in sections 4 and 5. So, as it says, you might describe that as a rebuttable presumption in favour of his release on bail. If he's convicted, then he no longer has a right to bail unless he's appearing in relation to a breach of a court order that was made when sentence was passed, or the case has been adjourned to obtain reports. And again, I think that's pretty much identical to the situation as far as, let's say, Section 4 of the Bail Act in England and Wales is concerned. So in terms of exceptions, again, in a kind of similar vein to the way that Schedule 1 of the Bail Act, 1976 in England and Wales, is divided up, one has to distinguish between defendants who are charged with imprisonable offences and those charged with non-imprisonable offences. So those who are charged with imprisonable offences or have been convicted of them, you can see the court considers there are substantial grounds for believing that if the defendant were released on bail, he would abscond, offend, interfere with witnesses, or otherwise obstruct the course of justice. The court need not grant bail. So they're big exceptions to the presumption of release on bail. And as it says there, if the court thinks the defendant will be at some risk if released, it may withhold bail for his protection, or if he's already serving a custodial sentence, they won't release him because obviously he's not going to be released. He's still going to be serving his custodial sentence. 3.26 makes a point that we've already thought about today as far as juveniles are concerned, so we don't need to revisit that, I think, now. 3.27, another classic reason for withholding bail: the court doesn't have sufficient information to make a decision. And as I've noted there, usually that only works at the very first appearance or production in court. I don't think it's very finite life in that sense. And as it says, if the court orders inquiries, social inquiry report, that type of thing, and it wouldn't be practical for whatever reason to provide those unless the defendant is kept in custody, then the court may so order. Factors, nothing out of the ordinary there. Then what's the nature of the offence? How serious is it? What do we expect to be the outcome? So if he's looking at a nailed-on custodial sentence for a substantial period of time, that will obviously be a relevant factor for the court to consider. What's his character, in particular antecedent history, as in criminal record, his association, community ties, who's he hanging around with, is there likely to be some kind of repetition or pressure put on him, that type of thing. Record of fulfilling his bail obligation to past. In other words, when the courts have in the past trusted him to attend court when he's required to, and he has met that trust successfully, that will go in his favour. On the other hand, if he has abused that trust by absconding or interfering with witnesses, that sort of thing, then that will count against him. Before conviction, strength of the evidence against him, because of course that's indicating what the likelihood of conviction, and then they can go and think about what sentence would be given if he were to be convicted. Is he already on bail? Courts, of course, hate this. Bail bandits, as they are sometimes described. So, notwithstanding presumption of innocence, if you're already on bail, got to keep yourself out of harm's way. And have you misused controlled drugs? Something else for the court to think about there. I don't think Guernsey has the same kind of regime as England and Wales currently does in terms of requirements for drug testing. No. All right, non-imprisonable offences then, as it says, and quite understandably, fewer exceptions to the right to bail, where, at the end of the day, even if he pleads guilty or is found guilty, he can't be locked up in terms of a sentence. So why would we keep him locked up before we get to those end points? So as you can see, exceptions to the right to bail there would be having previously been granted bail, he's failed to surrender as required, and that leads the court to the conclusion that he would have absconded if released on bail now, or kept in custody for his own protection. Again, futility if he's already serving a custodial sentence, or he's been released in these proceedings and then he has been arrested for absconding or in some other way breaching his bail conditions, and the court is now satisfied that if they were to release him again, substantial grounds exist to believe that he would either abscond, offend, or interfere with a witness.
One small point, maybe. The non-imprisonable list suggests that the person can be kept in custody for his own protection. If it's an imprisonable offence, the court has no point that it's not there to provide an alternative to care in a health facility. So where perhaps somebody is feeling that they are at risk of harming themselves, but they don't put the threshold for health and social care intervention. Now, they almost want to be remanded in custody. And I had that situation. I had a defendant who wanted to be remanded in custody for a number of reasons, but that was one of them. And the court said no, because the survivor absconding, committing an offence, or interfering with witnesses. And it's a difference between non-prisonable offence and non-prisonable offence. So you can't be remanded in custody just because you want to be, because you think you might get a custodial sentence and you'd like to start
serving it now. Yes, it was always said if you were pretty much guaranteed a custodial sentence at the end of the line, you'd be far better off just staying in custody now as a remand prisoner, because you had various entitlements like wearing your own clothes, having food brought in. I think a lot of those don't exist in England and Wales anymore, but it was an easier start to life as a prisoner. But
that's not a reason.
I have had a case where I turned up on a bail application and the prosecution objected to bail on the grounds of my client's protection, which came as a bit of a surprise to me. But they called a police officer. My guy had allegedly burgled. He lived on a council estate, and he'd allegedly burgled a lot of his neighbours' properties. And this being South London in the kind of Bermondsey area, apparently when the police were making their inquiries and trying to track down exactly who had been burgled by our hero, various kind of like ex-dock workers and people like that who'd been his victims made certain explicit threats that were he to show his face around there in the foreseeable future, he might not have a face to show anywhere. So that was an interesting case where the prosecution was saying, we object to bail on the basis of his protection. So.
Well, that's interesting, because the way you read it, it suggests that that's
purely for the defence to make, yeah.
Well, or that perhaps that's the difference. The prosecution makes it that's going to be successful, but in my case, the prosecution didn't want him to be remanded.
No.
And was objecting on technical grounds and saying, we're not asking him to be remanded. It's not for him to say that he wants to be remanded.
So if you've got suicidal crime who may be going down for prison sentence, then they would have to be assessed by hospital care as being someone who needs medical hospitalization, or what do you do?
No,
That's even not.
You have to refer to the medical. But the point was being made that that's not the role of the prison.
No, social work, basically, yeah.
When we not go to prison. But I don't understand how you can have a provision for the protection where it's not likely to.
Well,
it can't work.
All right, okay. Well, we'll think about that one. So, duty to surrender to custody, fairly self-explanatory. Primary duty, having been released on bail, is indeed to surrender to custody, as and when required to do so. Further requirements may be made, as it says, the person provides someone to be a surety to act as guarantor for their surrender to custody, or to give security for their surrender to custody. Security may be provided by the individual or on his behalf, unlike surety, which cannot be provided by the defendant, because promising to pay £10 billion if I don't turn up. Well, if I don't turn up, I'm not here. So thank you very much. Make it 10 trillion. Why not? Yeah. Okay. So, what else do we need to think about there? Yes. So just to be clear, the difference between those two: surety would be someone, as it says, acts as a guarantor. You promise that you will forfeit the sum of money if Sonny Jim doesn't turn up to court. Security, on the other hand, is put your money where your mouth is. Yeah. Pay in to court, and then we'll see whether he turns up or not. Yeah. But people do abuse that. The classic recent example of that would be, of course, Julian Assange, current native of was it Ecuador, I believe, or citizen of Ecuador anyway, who cost some people who I believe are still on friendly terms with him tens of thousands of pounds, either because they had stood as sureties and they were then ordered to forfeit either all or part of those sureties, or they provided security. They actually handed over cold hard cash to the magistrate's court, and that just got hoovered up when he decided to relocate to Latin America. So there you go. All right, so sometimes these things work and sometimes they don't. But you can see the kind of objectives at the top of page 66 of why people might be made subject to conditions. And there are all sorts of conditions. I don't think it serves any purpose for me to sit here and go through a list of ones, but I mean, obviously, reporting to a police station would be one, observing a curfew would be one, not contacting a witness would be one, probably not going within a particular area. I've had cases where defendant was required not to leave a particular area, lived in a village, was told he couldn't leave that village unless he was going to keep an appointment with his solicitor. Marquis of Blandford was, when he was going through a spate of bilking taxes in London, he'd just take a taxi anywhere he felt like it, and then when it got to roughly where it was dropping him off, or it stopped to drop him off, he just opened the door and run away. Which is a bit demeaning for a member of the aristocracy, climbing over garden walls and that sort of thing to get away from pursuing cabbies. But it was made a condition of his bail, when he was particularly prevalent at that sort of behaviour, that he couldn't take a taxi unless he was being accompanied by his solicitor. I assume that means a solicitor that couldn't run at least as fast as he could. But anyway, there we are.
Typical conditions for Guernsey, the surrender of the passport is fairly standard. And of course, because it's possible here to travel without a passport but with an ID, sometimes the driving licence as well. One always has to consider whether it's going to be not leave the island of Guernsey or not leave the bailiwick of Guernsey, because the bailiwick of Guernsey enables travel outside. Sometimes in the summer people ask for the bailiwick conditions so they can still go sailing, which wouldn't happen in central London. The doorstep condition, yourself at the door, if the police officer comes, there can be breathalyzer conditions if you're on a condition not to consume alcohol, and there may also be conditions not to drive in those sorts of cases. Those are ones that come about. And then the usual not to contact witnesses, not to go here, not to go there, and so on in the normal way.
Well, I've never come across breathalyzer condition. Yeah, okay. Interesting. All right. So let's see. Sureties. I think there's not a lot that we need to say that we haven't already mentioned there. I think in 335, the De Jersey case, I think we looked at that in the previous weekend, didn't we? It does ring a bell with me, where the court said that they didn't have the power to order forfeiture of the £10,000 that had been set up as a recognizance there. So I think we've looked at that already. I'm not going to go back over that again. 336, sureties have to be effective, as it says, those who will carry out their obligations to the court presumably have some kind of influence over the defendant, and most specifically will have that financial incentive to make sure that Junior turns up to court as and when he is supposed to. So as you can see, it's a criminal offence to agree to indemnify a surety, because that robs it entirely of its impact. Reviewing decisions to remand in custody. So if bail is withheld, the court has an obligation to revisit that at each subsequent hearing for so long as the defendant remains in custody. So at the next hearing following a decision to withhold bail, application may be made on any relevant argument, whether or not it was made at the previous hearing. So no change in circumstances, essentially, needs to be shown there. So 2 bites of the cherry, as it's sometimes described. But at subsequent hearings, court needn't hear argument which has previously been put before it. So there you go. It says they're probably just to save court time. Whatever the legal basis is, that's the way that the court operates. Appeals, prosecution can request reconsideration. So if the defendant is released on bail, having been charged with an indictable offence, then the prosecution can apply for that decision to be reconsidered. If it's court bail, then the application is made to that court. If it's police bail, then the application is made to the appropriate court. And as it says, the appropriate court is the one specified by the officer as the one before which the bailed person must appear. So that will potentially at least vary depending on the circumstances of each case. Application must be based on information that was not available to the court or police officer when the original decision was made. So essentially, we're looking at what, for practical purposes, would be a change in circumstance. Yeah. Has to be made in writing, set out the grounds on which it's being made. Appointment will be fixed for the hearing, and as it says, that will be fairly swift. Must be fixed for no later than 72 hours after the application has been received, because fairly obviously there's an issue about the defendant being detained until that matter is actually heard. And then if the court maintains the decision to release on bail, then if the court maintains the decision, it must state its reasons, which will then, as it says, allow the detainee to receive proper legal advice on whether to maintain any further challenge to that decision. Sorry, go on.
There is one condition: usual is not to leave the island or the daily record, whichever it is. Usually the island.
So, like, what, not to go within 100 metres of the ferry terminal, that type of thing.
No, just that.
Just not leave.
Attempts
Yeah.
to leave. So if they find you in the ferry terminal, then you're going to be appearing.
Unless you can find someone rapidly to be waving goodbye to. Just sing them off, yeah. Okay, yes. All right, prosecution appeal to a superior court. So not going back to the original court. Prosecution can appeal against the magistrate's decision or the ordinary court if and when it ever exercises summary jurisdiction to bail a defendant. But again, you can see there are limitations there, rather weirdly. Only applies where the D is charged with or has been convicted of an offence punishable with a sentence of at least 5 years imprisonment or twocking. I don't understand why those two are conjoined in that way, but you know, as is not a reason why. Yes, process must be instigated urgently. I mean, all prosecution appeals against release on bail have to be instigated urgently. That's just a fact of life. So oral notice given to the court that released the defendant on bail, and that will of course be before he's released so that he can be taken back down to the cells. Then written notice of appeal within 2 hours, etc., etc. I mean, this is pretty much word for word the situation for prosecution appeals in England and Wales. So nothing staggering there. Defence appeals. So defendant who's been denied bail by the magistrates court or by the ordinary court can appeal to the royal court. They need to see a certificate of full argument on the issue of bail. On that point, I'll just make a small point. So we were just looking there and seeing that you can have 2 bites of the cherry. You can make your application at your first appearance, fail, come back in a week's time, make exactly the same arguments to the court. Now, my view on that has always been that's how you do it. And at the end of that second unsuccessful application for bail, that's when the court issues a certificate of full argument, which then unlocks the door to the royal court. Colleagues of mine have suggested that they're far less patient than I was ever when I was in practice, and that at the end of that first appearance, if the court withholds bail, that you would then steam in and say, right, give me my certificate of full argument. I don't want to come back next week. I just want to go off to, well, in your case, the royal court, in their case, the Crown Court. So, you know, I don't wish to exercise my second bite of the cherry in front of you guys because you don't know what the hell you're doing. I want to go before a sensible judge in a proper court. So give me my certificate of full argument now.
If, for example, one of the reasons you haven't been granted bail is because you haven't got an address, then
yes, you might want time.
There will be no point in appealing. You just as well hang on and come back and you make your address.
Mm.
When you can, in general, you get back to the territory here. When you go up to the royal court after committal for plea, then you can usually make a third application for bail. You're not going to get much of a cheerful response if there's nothing very compelling to say. No,
and I think courts are usually unattracted by when a lot more time has passed. Effluxion of time is not normally a change in circumstance. No. Okay, all right, last couple of pages. Yeah, all right. 3.46, deemed appearance at court. As you can see, Following representations from prosecution and defence, court may deem the defendant to be present at court for any pre-trial hearing if he's being held in custody at a prison, but is able to see and hear the proceedings in court. So, and can be seen and heard by the court. So this is one of those kind of virtual court hearings that seems to be the vogue these days.
Committal. Yeah,
Yeah. Well, I suppose it saves money, more convenient. Yeah.
it's fine.
Yeah.
As is anywhere else.
Yes, yes. All right. Separate offence, criminal offence of absconding. Aside from the kind of primary offence that you're on bail for, if you don't surrender to custody, then you'll be committing a separate offence anyway under the bail law. As you can see, you have a defence there if you have reasonable cause, but the onus is on the defendant to prove that reasonable cause. And they can lose it if, once that reasonable cause ceases to operate, they don't whiz themselves into the court, the relevant court, as soon as it's reasonably practicable. So they've got to be fairly time conscious as far as that's concerned. Don't think we need to address ourselves with that not providing a record point. It's there. So the offence of absconding can only be tried by the court that granted the bail, or where it was police bail by the appropriate court, once again, subject to one exception. If a court commits a defendant for trial to the Royal Court on the main offence, it may also commit him for trial and indictment for the offence of absconding. And that just kind of makes sense, ultimately, I guess, from a sentencing point of view, because if he ends up having to be sentenced for two offences, it makes more sense for one person, or one entity, should we say, the jurats in this case, to be doing the sentencing for everything that's outstanding against him. Otherwise, there's all sorts of potential for confusion, conflict. The upper court complaining that its hands have been tied by the sentence that was passed by the lower court. So that's just a kind of sensible, coherent sentencing objective being fulfilled there. You can see the sanctions that can be imposed for that offence. And then last point then, 350 and 351, where a defendant is on bail and fails to surrender to custody, as it says, the court's very likely to issue a bench warrant enabling the police to arrest him, but he can also be arrested without a warrant in certain circumstances. So as you see, for example, he's spotted queuing for the ferry to France, or consulting the timetable for the ferry to France, perhaps. Anything like that. Officer has reasonable grounds to believe he's likely to break any bail conditions. So if he sees the defendant entering a pub where a prosecution witness is having a drink and there's no contact, something like that. Or was released on bail with a surety, and that surety has given written notice that he would like to be released from his commitment. That's never a good sign. So in all of those situations, the officer may arrest our hero without bothering to get a warrant from the court. If he is arrested without a warrant, he has to be produced, as it says there, to the court where he should have been surrendering in the first place, as soon as it's really practicable, in any event within 24 hours. So again, you can't hang around with a detained individual. And if the court then forms the opinion either that he's not likely to surrender to custody, or that he has broken or is likely to break any condition of bail, it can keep him in custody, release him on different, presumably more onerous conditions, or just re-release him out into the community again. Although I would have thought that third one is somewhat unlikely to be the case. As it says, if the court doesn't form either of these opinions, then it shall release on bail subject to the same conditions as were opposed, if any. I mean, if he's messed up, he's either going to be looking at little 1 or little 2 then. He's either looking at remand in custody or a release on more onerous conditions, frankly. That's what's going to happen.
Hang on, if he's not had any other conditions, then why would you go back to the court?
Sorry, if he doesn't have... Oh yeah, but he might have failed to surrender. He might have had unconditional bail but failed to surrender. Right, sorry, I've taken about another 15 minutes than I predicted there, so apologies for that. But we are stopping.
I just want to say something, because this is going to be broadcast to the nation.
I can stop recording if you like.
No, no, that's fine. I just support her, and I don't think I thought he was guilty because he had a perfectly good explanation as to why he had come to Guernsey and given all these checks and what have you. So I don't want to be unfair to him.
I'm sure no one would have understood your remarks in that way. And I'm sorry that I was smiling when you just said that. So we will stop there. Thank you, one and all.